Hey, get us outside, right now. Tommy? Come on, we need some help here. Okay, go ahead. What state say?
So Judge, I had first amendment notice back on August 6th of 2024. Given notice of intent to enhance his punishment under 1242F of the Texas Penal Code. It is my intention, if this is a guilty verdict, to read the remainder under paragraph 2 of that notice.
All right, legal heads, listen up. Prosecutor just cited Texas Penal Code 12.42F. That's enhancement based on prior felonies. Translation: if the defendant has a record, especially assaulting a public servant, the punishment could be much more severe. The question is, did the defense see this coming?
Like we would if it was a part of the indictment. And further presents that before the commission of the primary offense, the defendant was finally convicted of the felony of assault of a public servant on February 7th, 2017, calls number 1165 in the 21st District Court of Lee County, Texas. Gives him an opportunity to enter a plea of true or not true.
I object that it's not part of the indictment, even in the indictment, judge. It was just given notice and that, to me, that's different. It has to be put on through evidence in reference to his prior. It's not part of the indictment that was presented to the jury, part of this record at this point.
Tension alert. Defense is pushing back hard, arguing that notice of enhancement wasn't part of the original indictment. Why does that matter? Because if due process wasn't followed, the whole enhancement could be tossed. Stakes sky high?
My response to that is an indictment is just about notice.
Mhm.
So if we give someone the intention that if we give them notice in this written form, it's considered proper. We do it all the time.
I understand.
Actually, it was at the time, this was at the court's behest when we tried this case first time.
What's the,
Well, we never got to that.
what's the date that you're using? Because I've got,
I thought my file mark date for this notice was August 6th of 2024. That was me amending the prior notice because I think there was a mistake in the number of district.
okay, this is the first amended notice of state's intent to enhance punishment.
Correct, Judge.
You've received that, discussed this with your client a year ago?
Yeah.
Okay, you're on notice
On my notes.
and it's formally filed. I don't see where there is a formality that needs to be made where he has to plead true or untrue. I know the way we do things on the enhancements on paragraphs that enhance subsequent paragraphs to the primary charge on indictments. But the key is given fair notice and of what the state intends to prove. And at the end of the day, he can stand by the presumption of innocence, and the law states that your burden is to prove it. Even when you plead true, when a plea of true is done, supplemental evidence is made to support the plea. But the defense acknowledges you're on notice. You've been aware of this first amended notice of the state's intent to enhance punishment with a alleged prior felony of assault of a public servant on February 7th, 2017, and cause number 1165 in the 21st District Court of Lee County, Texas, which the state intends to present before the jury and presumably ask for enhancement of punishment if the defendant is found guilty.
Now it gets real. The state is gunning for a potential life sentence, 15 to 99 years. Imagine hearing that in court. If you were on the jury, would a prior assault charge change how you feel about the current case? Drop your take in the comments.
Punishment uh, would, can be enhanced to no less than 15, nor more than 99 years confined in prison or life in prison.
Yes, sir.
And defense acknowledges that notice of those allegations have been received, and you've discussed that with your client. Okay. Is that true, sir? All of this, you're aware that
Oh, yes, sir.
that this prior conviction can possibly be presented before the jury, which would enhance your punishment range.
Yes, sir.
And you've discussed that with your attorney.
Yes, sir.
In the event you're found guilty, if it's not guilty, you're walking out of it.
Yes, sir.
Okay.
In theory,
In this area somewhere.
but he's got other pending charges.
Oh, that's right. We've got a couple of other indictments pending. But that would end this case if they're not guilty. All right, we've got a verdict. Let's bring the jury out and receive the verdict. Thank you. And I'm going to ask you a couple of questions. Number one, the court has received a message from the jury that the jury has reached a verdict in this case. Is that so, sir?
Yes, sir.
Is this a unanimous verdict? That is one that is agreed upon by all members of the jury?
It is.
Do any of the jurors disagree with your four persons representations? No disagreement. It does appear to indeed be unanimous. If you would be so kind, pass the documents to the bailiff. You may be seated. I will review for proper form and publish the verdict. And the defendant shall rise. In cause number 22-39014, the state of Texas versus Stephan Rayvon Angel, we, the jury, find the defendant guilty of the offense of murder as charged in the indictment signed by the jury foreperson.
And boom, guilty. The jury finds the defendant guilty of murder. That's the end of phase 1, but buckle up. We're heading straight into the punishment phase, where that enhancement could tip the scales big time.
The verdict is received. It is made a part of the record for all purposes. Ladies and gentlemen of the jury, at this time, I have accepted your verdict finding the defendant guilty of the offense of murder as indicted in this case. And that brings us to a close of phase 1 of this bifurcated two-part trial. We will now proceed with the punishment phase of this trial. And once again, let me repeat, you are still under the instructions that the court has given to you up to now. Let me see lawyers, please. Thank you.
That's what Lois is here.
Yeah, I see. Hey, just outside, right now. Tommy, come on, we need some help here. As the court would place in the record, within the last hour, the court received a verdict from the jury in the case of Stephan Angel in a murder case, and the jury found the defendant guilty of the offense of murder as alleged in the indictment. So the court accepted the verdict and then broke for the lunch hour. And as participants and the jury and spectators were leaving the courtroom, this court saw some activity at the doorway, and I could see one or two bodies, and it was obvious that physical confrontation was going on at the doorway, inside the doorway and at the doorway of this courtroom, as the court was still in session on this matter. I've reviewed a video because we got videos everywhere, and I see three people flailing, punching at each other at the doorway of this courtroom and breaking some of the chairs outside, but it was a free-for-all fist fight going on. Y'all three, I recognize all three of you. This is a court of justice, a courthouse of justice, of honor. This is the last thing that should ever happen in this building, because we're trying to resolve problems in a humane and dignified and educated and advanced method. We're not cavemen, although you three acted like it, like we were back in the caves again, without any rules, without any sense of respect for each other. The proceedings moved forward in due process. The jury had their job, the attorneys had their job, and then we went through the penal code, the code of criminal procedure, and the rules of evidence to get to a disposition in this case, like we do in every case, using the rule of law, not fist fighting in front of the public. Can you imagine if this is what we did normally? We don't really need a building. We just meet and punch it out. We're not cavemen. We're supposed to be advanced thinkers. But not everybody thinks advanced thought. That's foolish. That was foolish. And I see assaults. Now, I understand that no one wants to press charges against anybody. But let me tell you this, I'm pressing the charges. You do it at the door of my courtroom while in session, you're going to get held in contempt of court. All three of you are charged with contempt of court. Carries with it up to 60 days in jail, 180 days in jail, 6 months, 6 months. And don't think I won't set an example, because this isn't going to be the kind of activity that decent, law-abiding, advanced human thought in America is supposed to be about. And it'll be made an example out of. And we got the video, and it didn't happen exactly in my presence. So it's going to be what's called constructive contempt. It still happened over this court's authority and power at the door of its courtroom while in session, which means I can't hold a hearing right now. But what I'm going to do is you're all arrested. You're going to go to jail, and we'll bring you back, and we'll have hearings on each of these cases, and I'll get to make the determination up to 6 months in the county jail. And don't you think I won't make an example, because this isn't the kind of behavior which you can do and then walk away from it as though nothing happened. We're supposed to set examples of behavior for all of us. And some of these cases have terrible situations. I presided over the James Byrd murder cases. I was one of the prosecutors. You don't think that was hostile? Because there were a lot of folks who felt like justice needed to be served in different ways. But we did the rule of law. The rule of law worked. Those people were prosecuted and then executed for what they did. You don't think that the experience and the sacrifices that we put in to see humanitarian ways of doing justice and the rule of law and due process works? Or is there another way? No, it worked so that the people knew that this Constitution, the flag, and the rules in the Constitution are something to be honored, that we handle our problems in a disciplined, mature, advanced method so that we are the example for the rest of the world. But that's not the way that worked out there in that doorway. All y'all did was that acted like the kids do at school grounds before we learned and get educated, duking it out there in front of everybody. People are here to resolve their problems in an honorable disciplined way under the rule of law. What kind of example is that set that y'all can duke it out and just flail at each other, break things, and disrupt the proceeding? Disrupted my proceeding. I had to stop the proceedings that we were conducting here to finish this. But you got my attention, and you're gonna have hearings, each of you, and I'll get to make the decision because you don't have a jury trial that's in front of me. And you can be ultimately sentenced in jail up to 6 months. Does everybody understand that? All of you? Okay, I need everybody's names. Yours first, sir.
Charles Nicholas Jr.
All right. Spell your first name. Is it Charles?
Yes, sir.
Your middle name, sir?
David. David
And surname, last name?
Nicholas. Nicholas.
And you, sir?
Charles Nicholas Senior.
And you, sir? Your name?
Last name Angel. First name Steron.
How do you pronounce that? How do you pronounce it? Steron? Steron?
That'll do.
Okay, what we call this is what's called constructive contempt. That means it didn't completely happen in the court's view, but it happened where it disrupted the court's lawful duties in our hearings because it all occurred at this doorway. Turn your phone off, please. Thank you. It's called constructive or indirect contempt. And again, this is what's called criminal contempt rather than civil contempt, because you can be placed up to 6 months in the county jail. So all of you will be arrested. Each of you are going to be, there's a bond that I'm ordering of $1,000 in each case. For each case, I'm going to set this for a hearing in 4 to 6 weeks. And if you're unable to hire an attorney, one will be appointed to represent you. Are all of you going to be able to hire attorneys, or are you going to need appointed attorneys? Sir, you're going to hire somebody, and you, sir, Ms. Point, you want somebody to point? We're going to get you to fill something out. I need him to do an indigent form. If you're indigent or unable to hire somebody, one will be appointed immediately to help you, okay?
Y'all hold on, we're gonna take him into custody properly before he fills that out. You want to take those cuffs off.
That would be done on later. Okay. I think that's, you've been given notice of what you're charged with. Assault is under section 22. A person commits an offense of assault if the person intentionally, knowingly or recklessly causes bodily injury to another, or intentionally or knowingly threatens another with imminent bodily injury, or intentionally or knowingly causes physical contact with another when the person knows or should reasonably believe that the other will regard the contact as offensive or provocative. The offense is generally for assault, a Class A misdemeanor, which carries with it up to 1 year in the county jail. But the court on proceeding with contempt in a contempt proceeding, again, can sentence the offenders up to 6 months, but you have an opportunity to be heard with due process and present evidence on your behalf in to answer the proceedings. And again, criminal contempt is punishable because it concerns an act which affronts the dignity and authority of the court. And the primary purpose of criminal contempt proceeding is to vindicate the public authority. And committing assaults in the doorway of a courtroom where in this courthouse where justice is the determining goal in all of our proceedings in a dignified and non-hostile way of advanced human actions and thought. That's the way we're supposed to conduct ourselves. And every case has emotional issues. We never have problems like we had just a moment ago. And that cannot be tolerated, and it will not be. It will have its punishment attached to the actions. Does everybody understand? All right, that is all. We're in recess on this. Then you are all taken into custody and $1,000 bond.
Can I
is ordered.
No, we'll take care of it. We're gonna have a story on
Sure, yeah, talk to the bailiff and they'll work it out with you. Thank you. We're in recess.
The judge doesn't hold back contempt charges, possible jail time, and a firm reminder that justice is supposed to be civilized. After everything, this case isn't just about guilt or innocence. It's about the system holding the line when emotions boil over.